So welcome everyone. Today we have a very extensive program. Today we are discussing about the Standard of Foreseeable Relevance in Privacy Enhanced Tax Information Exchange, the FCInet ma3tch technology. And we will start with this meeting first giving us some welcome words from us at Leiden Law School, Leiden University. We are here at the Faculty of Global Governance, FGGA, Faculty of Global Governance Affairs. We have some people here in the room that are also presenting, some of them here today from FCInet, the executive board, some participants, attendants, but we have a lot of people online. And that's the reason why we are trying to do this hybrid as much as possible, trying to have still the two sides, the side of Bangladesh, the side of Ecuador, the side of somewhere in Europe, but also here in The Hague. So without any further ado, I will just give the word to Mariela Pina, who is the director of the FCInet Secretariat, for her introduction.
Ladies and gentlemen, esteemed colleagues, on behalf of the FCInet board, it's my great pleasure to welcome you all to this important conference. Today, we will discuss the outcomes of the study entitled The Standard of Foreseeable Relevance in Privacy Enhanced Tax Information Exchange, case study on FCInet ma3tch technology. As you know, FCInet was created to strengthen international cooperation in fighting tax avoidance, misuse of the financial system, financial crime, tax fraud, and related subversive threats to society. From the very beginning, FCInet has combined two critical goals: enabling investigators to detect relevant information with peers and share it effectively across borders and domestically, while at the same time safeguarding privacy, data protection, and security. This delicate balance has always been at the core of FCInet. The earlier University of Groningen study confirmed that FCInet, with its built-in ma3tch technology, could operate within existing legal frameworks. This opened the possibility for tax agencies to start using the system in practice. As they did so, however, new and very relevant questions emerged. In particular, how should we understand the principle of foreseeable relevance in the context of this innovative technology? At what point can we say that information is foreseeable relevant? And how do we ensure that privacy protections remain strong while still supporting effective cross-border investigations? These were not just academic questions. They came directly from the tax agencies using FCInet who wanted clarity and certainty in their work. To address them, the FCInet board commissioned an independent follow-up study, which Leiden University School of Law has now delivered. The FCInet board also collaborated by providing input to the researchers throughout the process, ensuring that practical experience and needs were fully considered. This research, carried out by leading experts from the Institutes of Tax Law and Criminal Law, provides valuable legal, technical, and comparative insights. It also offers practical recommendations for how we can apply foreseeable relevance in a way that is both effective and responsible. At this point, I want to express my sincere gratitude first to the researchers from Leiden University, especially the lead researchers, Dr. Esther Huiskers and Professor Emma Mosquera, for their excellent and thorough work and for organizing today's conference. Second, to the FCInet board for commissioning the study and contributing their insights. And finally, my own team, the FCInet Secretariat, for their dedicated support throughout this process and in making today's gathering possible. Today is about reflecting on things together. I encourage all of you, experts, practitioners, academics, and policymakers, to share your perspectives openly. By doing so, we can ensure that FCInet continues to grow as a collaborative instrument that not only strengthens international cooperation, but also sets the standard for privacy-enhanced information exchange. On behalf of the FCInet board, I thank you for your commitment to this work, and I wish us all a productive and inspiring discussion. Thank you.
So let me just give the word to Esther. Esther, please.
Okay, thank you, Emma. Thank you, Jules, for this nice introduction. After this interesting presentation on how FCInet match technology works, I will try to place this technology in the context of international tax information exchange. Mariella already explained to us that since the turn of the century, the international exchange of information. The exchange of tax information has become a vital tool in the combat against tax evasion, tax fraud, and other financial crimes. And governments, they face a dual challenge, either to combat this tax evasion, and on the other hand, Mariella told us, the protection of the rights of taxpayers. And this balanced approach is experienced with the technology of FCInet ma3tch. And that was one of the reasons to introduce this technology. So in our study, Jules already told us we basically focused on the interpretation of the foreseeable relevance principle. And we built on, as far as possible, previous research of the University of Groningen. And we investigated 4 research questions. 1, how should the principle of foreseeable relevance be interpreted in relation to the spontaneous exchange of information via FCInet ma3tch from a tax perspective? And what criteria do competent authorities and jurisdictions involved in our study, what do they distinguish to assess whether the principle has been met? And how, the third question, is this principle related to the right to privacy and the protection of taxpayers' data? And the fourth question, how should the concept of foreseeable relevance compare to the requirements for information exchange in the criminal proceedings? And in this presentation, I will focus on question 1 and 3. Janemieke, she will discuss a few aspects of question 4. And later on during this conference, Tovik will discuss some issues related to question 2. Since the ma3tch technology is exclusively a bilateral exchange, Jules explained to us. That's why we focused in this study on Article 26 of the OECD Model Convention as a general framework. And Article 26 divides 3 methods of exchange: spontaneous, automatic, and upon request. This does not alter the fact that there are also other instruments of information exchange that will give us valuable insights. But we focus, especially because all exchanges with the ma3tch filter are bilateral, we focus on Article 26. And the University of Groningen, they established in their research that the ma3tch technology should be considered a spontaneous exchange of information. So we built further on this research of the University of Groningen. And let me share some insights from the technical operation in the context of this international tax information exchange. As Jules explained, in the startup phase, the first phase, tax authorities, the sending state, they select personal data to create the ma3tch filter. And this data is standardized, converted into compressed, non-reversible double hashed data. And this sending state decides autonomously whether and with which country they will share the filter. In this second phase of the process, the execution phase, that is the phase where the match technology comes into play, and also the question of the foreseeable relevance standard and when this standard should be met in the process. To meet the standard of foreseeable relevance, the matched data must at least be able to be of interest for the receiving state. And this should be the case at the moment of sharing the filter. So as from the moment of sharing the filter, foreseeable relevance standard must be met. And the requirement of at least be able to be of interest is a less onerous requirement than the requirement of some degree of knowledge, which is required for an international exchange of information based on a request. So there should be at least a minimum link. An ongoing investigation or examination based on well-founded suspicions is generally assumed a minimum of relevance, as it implies a reasonable suspicion of non-compliance with any legal obligation in the sending state, which may be indicative for the receiving state of any relevance for this state, for their taxpayers and individuals under an investigation. And the match technology is used for taxpayers already under investigation, so that a minimum link will be assumed to be present quite easily. All individuals in the filter are in the basic case subject to an investigation or an examination in the sending state. So the foreseeable relevance principle must be met at the moment of sharing the filter. And since this is a spontaneous exchange of information, a minimum link is enough. So in principle, the foreseeable relevance standard should be met at the moment of sharing the filter. However, in a few tax treaties, there are provisions requiring the sending state to grant authorization before the information is shared. For example, to use information for purposes other than taxation, or to submit the information to a third party. That could be a third country, but it could also be a law enforcement authority in the criminal domain. So in a very few cases, the foreseeable relevance standard must be met earlier than sharing the filter. But given the global drive for the widest possible international exchanges, these cases are rare and they will further decline in number. The use of a so-called whitelist, which means that in advance the sending states give their authorization to use the information also for other purposes, at least authorization from the sending state is no longer required. So the use of a whitelist may be helpful in cases where, in the very rare cases that the foreseeable relevance should be met earlier than the moment of sharing the filter. For FCInet and the participating countries, it is important to know whether such provisions apply. And therefore, we have recommended to create oversight countries where these conditions are applicable. And to get this oversight, we have made a questionnaire on page 75 of the report that can be used to have this oversight and to see for which countries certain conditions are still applicable. But these cases are again very few and very rare, but it is important to know whether this is the case or not. Let's go back to the technical operation. Jules already explained to us that the receiving state can check the filter by comparing its own database with the shared filter. And this comparison may lead either to a hit, which means that a match between the person in the database, the receiving state, and the sending state is very likely. This comparison may also lead to no hit, which means that there is no match under the shared filter. So a hit means that data in the receiving state's database may also be present in the database of the sending state. However, there is a chance of a false positive. For instance, when the receiving state detects a hit, but the hit is not the same as the person in the database of the sending state. So to ensure whether it is the same person, the receiving state must always go back to the sending state to verify the hit. And even if the filter contains compressed, double-hashed data that cannot be traced back to the individual, a validated hit means that the person behind it has been identified and that the data in the filter should, in hindsight, be classified as pseudonymized and thus as personal data, triggering data protection rules. So in each phase, from selecting the data to validating hits and providing text information, each phase of the process may result in a breach of data protection rules. But this is generally proportionate given the public interest in an effective tax enforcement. And even if this breach is minimal, the requirement of foreseeable relevance is not only a prerequisite for the lawfulness of sharing the filter, but also for compliance with the data protection rules for tax purposes. So to conclude, this privacy-preserving match technology allows tax authorities to identify potential matches between databases without disclosing personal data, unless a hit is validated and the receiving state can ask targeted tax questions. Finally, sharing a filter does not constitute a phishing expedition, being a random data request without a clear investigative link, because one, ma3tch targets individuals already under investigation. It prevents so-called bulk requests. And finally, it limits follow-up for tax purposes to cases when there is a match. Thank you.
And now we have one person online who is actually in Leiden. We are here at the Faculty of Global Governance in The Hague. Janemiek Oudekerk, Professor of Criminal Law, and she's at the Faculty of Law in Leiden. Unfortunately, she could not be here in The Hague, but because of other commitments, but she wrote her part together with Anna ma3tch, and Janemiek will present it today. Janemiek, the word is yours.
Thank you very much. I hope everyone can hear me. If not, let me know.
We cannot hear you, Janemiek.
Yeah, perfect.
Let me
In the
see.
meantime, I will share my screen so that you can see some slides. So if it works, then you can now see the slide. Irma, thank you for introducing me. Irma already mentioned Anna ma3tch, my colleague from the Criminal Law Department. And I have to say that most credits for this part of the research go to Anna. She is not able to attend this conference because she is on maternity leave. I'm not able to be in The Hague, indeed. I'm terribly sorry about that. But indeed, after this session, immediately after this session, I have other commitments here in Leiden. So I will share with you some reflections from a criminal law perspective, which has been laid down also in chapter 5 of the report. And perhaps it's very evident for most of you, but if not, let me very briefly explain first why the criminal law perspective is relevant. Well, of course, as most of you probably know, there is, compared to in the past, there is a fading divide between administrative investigations and criminal investigations, which also has consequences for investigations in tax matters. And the divide may also differ across national jurisdictions. So in the Netherlands, for instance, that's relevant for the research, what I'm now going to say. In the Netherlands, for instance, it are administrative authorities that are not only competent to supervise taxpayers, but also to investigate tax fraud, whether it concerns administrative or criminal investigation. So that's just to underline how the divide can have been faded. Well, as a consequence of this, the information exchange and the gathering of evidence that takes place in administrative tax proceedings can be used in criminal law proceedings. So evidence gathered in administrative tax investigations can be admitted, can be added to a case file in criminal law proceedings. So this is why we thought it would be good to review the foreseeable relevance criterion also from a criminal law perspective. But please note that instruments for criminal law cooperation do not as such use or mention the concept of foreseeable relevance. So this is why our research question for this part of the research has been how the concept of foreseeable relevance compares to requirements for information exchange in criminal proceedings. That, put differently, would the use of the ma3tch technology actually be problematic for the purpose of information exchange in criminal matters? Well, as we have concluded in the report, it seems to be comparable. So it doesn't seem to be problematic the ma3tch technology for the use for the purpose of information exchange in criminal proceedings. There is, I have to make a small disclaimer because the research that we did for chapter 5 of the project was limited in time and scope, as will follow from the rest of my presentation. But our findings so far have been positive. So there is a wide array of instruments, legal instruments for cross-border cooperation in criminal matters. There are many bilateral instruments. There are also a lot of multilateral instruments, and these multilateral instruments can have the form of treaties, so treaties from the UN, of the Council of Europe. But there are also multilateral instruments that find their basis in EU law, such as in EU directives. Most significant for tax fraud cooperation are a number of multilateral instruments that we have involved in this research. And it's good to mention beforehand that these instruments are generally applicable. So they do not only apply for cooperation with regard to tax fraud, but they can be relied on for basically any cross-border crime. And that is a common feature that of cooperation instruments in criminal matters, but that's good to mention beforehand, perhaps. So let me show you which instruments we have. Sorry, I see a message from Irma that I do not understand, so I will continue my presentation. Otherwise, just break in, Irma. Here you can see the overview of the multilateral and generally applicable legal instruments for criminal law cooperation that we have used in our research. And as you can see, we have made some distinctions here that are relevant in the field of criminal law. I will explain these very, very briefly. But before I do that, let me also emphasize that most of these legal instruments allow for information exchange upon request, as well as without prior request. An exception to that is the directive from 2014 on the European Investigation Order that only allows information exchange upon request. As you can see in the overview, some of these instruments concern instruments for judicial cooperation, others police cooperation. This is a relevant distinction in criminal law that very briefly explains as that police cooperation covers all kinds of cooperation between national police forces that do not involve the need or that do not involve the use of coercive measures. That makes it different from judicial cooperation, which covers cooperation between judicial authorities such as prosecutors, judges, investigative judges, for instance, but also specialized law enforcement authorities, which do involve the use of coercive measures. Of course, the actual this may, of course, involve that police officers are deployed, but there is this supervision from judicial authority because a coercive measure is involved. So another distinction that you can see in the overview is between formal and informal cooperation. And it's good to mention here that this is a criminal law specific distinction that might be from a tax law perspective. You might have certain ideas about this distinction, but let me explain that in the context of criminal law, both formal and informal ways of exchanging information have a basis in legal instruments. So in the legal instruments that are here mentioned on the slide. They differ, so formal cooperation differs from informal cooperation in the intensity of legal requirements that must be met in order to actually proceed with the exchange of information. In the case of formal exchange, in formal cooperation, the exchange of information is subject to detailed legal requirements, and that is because formal cooperation aims to collect evidence abroad for judicial use, while informal cooperation, which means the exchange of information through simplified channels, on the basis of which simplified channels upon which law enforcement authorities and judicial authorities can rely, they only assist or reinforce foreign investigations. So they are not geared towards the collection of evidence or their judicial use. And that explains why this exchange of information can then take place more informally. Informal cooperation can take place on request, but can also take the form of spontaneous exchange of information. And actually, the spontaneous exchange of information is a way of information exchange that is widely used both between law enforcement authorities and judicial authorities. So let me now go to the findings of this part of the research. I will share with you 3 key findings and then come to the conclusion. So the first key finding is that the exchange of information on request must meet requirements that, as we have argued, suggest that they resemble the requirement that the provision of information is foreseeably relevant. And the requested authority is, under the multilateral information that we have examined, always required to indicate the object and the reasons of the request. And as we have said, this hints to the fact that the relevance of the requested information must have been established. I give you just one example from one of the instruments that we have examined. So the European Union Directive on the European Investigation Order, which is the legal basis for basically all mutual legal assistance between EU member states. As follows from the directive, issuing authorities are bound by requirements of necessity and proportionality. They're also demanded to provide sufficient elements to establish that the requested information is linked to an ongoing proceeding, investigation, and that it is needed for the purposes of that investigation. And the sufficient elements that have to be established or to be provided, it's quite a lot. I'm not going to mention all of them, but one of them also is why the information is needed for the purpose of investigation, the reason of exchange, the object of exchange, a description of the investigative measure that is requested, and which evidence they want to obtain. If these requirements are not met, the directive provides for grounds for refusal. This is just one example. The report, of course, has described the requirements that also follow from the other multilateral instruments. So this about the exchange of information on request, but also for the spontaneous exchange of information, which widely take place in the context of criminal matters, which also, as I previously mentioned, is a form of informal exchange of information. Also for the spontaneous exchange, the instruments that we have examined suggest the requirement of a link between the information and the aim for transmission. This follows, for instance, from Council of Europe Mutual Legal Assistance Convention from 1959, or to be precisely, Article 11 of the second additional protocol to this convention, as you can see on the slide. It also follows from an EU directive relating to police cooperation, Article 7. It requires objective reasons to believe that information could be relevant to the other member state for the purposes that you can see on the slide. It is true, by the way, that we see in the context of spontaneous exchange of information that there is a more flexible notion of relevance being applied. For instance, the objective reasons under Article 7 of the directive has not been further defined or explained explained, for instance, in the preamble or in explanatory documents. So there is more flexible notion, but still it is clearly suggested that a link between the information and the aim for transmission is required. We have read the previous findings in combination with the requirements regarding data protection. Also, if we read all these requirements in combination, we can still argue that the lawfulness of data sharing demands a clearly identified purpose for the exchange, and that the relevance and necessity of the data in light of that purpose have to be evaluated. So the legal framework relevant here has been laid down in an EU directive, and as you can see on the slide, there is a number of articles relevant here. For instance, so it's not the complete information, but just to give you some idea of what is required here, the requirement that data are collected for specified, explicit and legitimate purposes must be adequate, relevant, not excessive in relation to the purpose. There is also Article 20, which requires data protection by design and by default. So this brings me to my conclusions, and my apologies for that I have to be very, very short, but it's all in chapter 5 of the report. So overall, we have concluded that the concept of foreseeable relevance compares to the requirements for information exchange in criminal proceedings. Put differently, the design of the ma3tch technology does not appear incompatible with all the aforementioned standards. And I said before, I need to make a disclaimer. This part of the research was limited in time and scope, but it's seemingly not incompatible. Even more, what we have seen is that FCInet ma3tch may even offer enhanced protection for individual rights. Why is that? It's because the moment of data access is shifted to the receiving authority. Put differently, the moment in which the filter is shared is not the moment in which the providing authority sends or discloses text information. Instead, the moment in which the receiving authority is able to access the information is by detecting a hit and a subsequent validation and a text information request. And therewith, we think that the ma3tch technology provides for a considerable minimization of privacy and data protection interference, because there is an interference, but it's minimal. And we have qualified that as a positive development. Nevertheless, it has been concluded in chapter 4 of the project that it is not completely precluded through the user protocol of the technology that potentially discriminatory characteristics will be used. It is true that the user protocol does not specifically allow the creation of filters based on values of skin color, religion, etc. But the unconscious use of potentially discriminatory characteristic cannot be completely ruled out, as was concluded in chapter 4. And that is why we thought it would be good to consider for the future the establishment of common rules on how data ought to be selected or not. That is, before these data are used to create filters and hashes. We think that the establishment of common rules on how such data ought to be selected or not within the national entities could help to even prevent the use of potentially discriminatory characteristics. But overall, we have, as I said, considered the technology a positive development. Thank you very much for your attention.
Thank you so much, Janemiek. So we will continue. You will be here still, you have like 6-7 minutes. I ask people, if you have any questions, just ask them in the chat, but also here at the audience, so we see whether there are any questions. I think what is important to see, we just provided the link to the report. And as you see in the report, we have summarized in less than 40 minutes, 179 pages. And that's a lot. So that means that if you are interested, please just have a look at the report. We thought that was important, and that's the reason why we are not only providing a tax law perspective, but we are also providing a criminal law perspective, because also the FCInet technology is being used for tax crime, money laundering, and so forth. So this is important to have also foreseeable relevance. And as you see, tax and criminal law are different. So we had to ask tax lawyers to look at criminal law perspective, criminal lawyers to ask tax law. So this has been a very interesting exercise. Hopefully you can see that in the report. Then after we still waiting for some questions. I don't see anyone in the chat, but if you have anyone has here any questions? No, we are great. Then this is great because what we are going to do, we have time for a coffee break. So we will have a coffee break approximately of 8 minutes. So not 10, not 15, 8 minutes. And since the problem is that because we are in different time zones, I say 8 minutes, now will become 8 minutes. So 20 minutes past the hour, depending on where you are at this moment in the world. So we will have a coffee break. And then after we will have the experience from OECD tax administrations, as well as from the Inter-American Center of Tax Administration, Gonzalo Arias. So looking at the international developments, if we are talking about this FCInet technology, how does it work? What are the challenges? And we have asked Gonzalo Arias from the Inter-American Center of Tax Administration, Director of International Taxation, to also address some issues regarding the FCInet, also asking questions. So it's kind of an open conversation. And thereafter, we will have 3 representatives from the OECD, the head of tax unit for foreign harmful tax practices, the head of tax unit for foreign tax administration, and Karin Kokar, who is a tax policy advisor in the Global Transparency Forum. So any questions that you can have, just ask in the chat. I will try to address that. At this moment, I will say, since I'm talking more than what I'm supposed to be, you still have 20 minutes, so past the hour. So thank you so much, Janemiek. We will be back in 8 minutes. Thank you so much. Yes, Gonzalo. So please, perhaps you can introduce yourself. I say a little some things about you. But if perhaps you also a little of your background, because there is a reason why we ask Gonzalo Arias from the SIAT, not only because of the SIAT, but also your work experience before in the working part in 10 on exchange of information before when you were working at the Argentinian tax administration. So please go ahead, the floor is yours.
Thank you, Irma. Thank you for inviting SIAT to be part of this webinar. I'm happy to have the opportunity to share with you some ideas on the report and the FCInet technology. And congratulations, Irma, and the co-authors of the report. I find it very useful for Latin American and Caribbean countries to understand how FCInet works and, in general, how to apply or interpret the forcible relevance principle in new scenarios. In my opinion, forcible relevance is one of the most relevant exchange of information topics. I remember that several years ago, in 2010, when FATCA was issued by the US government and the first discussion about the common reporting standard began, I wrote a post for the SIAT blog. Its title was Exchange of Information and Fishing Expeditions. In this post, I shared some ideas on how to interpret the forcible relevance principle when addressing automatic exchange of information, spontaneous exchange of information, and other cooperation mechanisms. After 15 years, this post is current and the forcible relevance principle is still a hot topic. Why? First, the forcible relevance principle is not written in stone. It could be a social construct, since its interpretation can be flexible. For example, you remember that in 2012, the paragraph 5.2 of the commentaries of the Article 26 of the OECD Model Convention was updated to consider that under certain circumstances, group requests are not fishing expedition. It is a proof that the forcible relevance principle evolved. The second one is that it is also important to adopt clear criteria on which procedures are governed or in a strict sense are governed by the forcible relevance principle. For example, just exchange of information or requests, or also automatic exchange of information or a spontaneous exchange of information. There are still dilemmas among competent authorities on how to interpret the forcible relevance principle at the operational level, on whether to accept or reject a request of information. I remember that regarding this last point, last April, with some partners, the Spanish Cooperation, the Spanish Fiscal Institute, the World Bank, and the Global Forum, we organized in Guatemala a 3-day workshop just on forcible relevance principle. After the workshop, I realized that we all think we understand perfectly the principle, but the situation changed when it comes to applying it. I consider that in Latin America and the Caribbean countries, there is a favorable context to adopt the FCInet solution or technology. There is a powerful tax cooperation tool in force, the Multilateral Convention. According to the OECD data, 88% of the Latin American and Caribbean countries signed the Multilateral Convention, and 88% of these countries have it in force. Most Latin American and Caribbean countries are largely compliant according to the existing Global Forum peer reviews report. And 2 weeks ago, we organized it in Montevideo, a meeting with 20 tax commissioners with the aim to identify priorities, not the tax administration priorities, their priorities. You have to consider that usually tax commissioners have urgencies or a long midterm or short-term expectations or objectives. And their priorities are to identify high-impact technologies and enable the necessary regulatory frameworks, totally in line with the FCInet, to apply artificial intelligence to critical tax administration processes, to guarantee resources for IT investments, and you know that an investment to invest resources is necessary to adopt FCInet technology, consideration of illicit flow in risk management, development of algorithms to mine information, leveraging international tax instruments and tools for mutual assistance and information exchange. You can see all these priorities relate to what FCInet offers. However, it is necessary more dissemination efforts to motivate Latin American and Caribbean tax administrations. Despite having disseminating FCInet in several events and with different partners, I get that most Latin American and Caribbean authorities don't know the system or its advantages. You know that we live in a dynamic context and authorities change. Sometimes in some countries, in some Latin American countries, they're changed twice a year or 3 times a year. So that's crazy, and it's hard to motivate authorities and to transmit knowledge. Regarding Latin American and Caribbean countries' willingness to implement this technology, I suppose it depends on each country. For example, the political will, maturity level, and resources. Not all countries are similar. We are in the same region, but there are big differences between tax administrations and legal frameworks. On the other side, I guess that FCInet is a great tool to motivate intelligence tasks and to promote a vision of single government, especially because just few Latin American and Caribbean tax administrations have experience in tax intelligence. For example, Brazil, but in other tax administration, tax intelligence don't exist. Some people confuse tax intelligence with risk management. For example, risk assessment is the process of identifying, analyzing, and evaluating potential risk, while intelligence is the broader practice of gathering and analyzing information to understand threats and make prediction, for example, to find the hidden data. Let's think of intelligence as the input and risk assessment as a specific of tax intelligence as the input and risk assessment as a specific output. Precisely, the FCInet system is an intelligence support tool which can motivate tax administration to undertake intelligence tasks. Regarding the vision of a single government, we always recommend tax administration to improve horizontal cooperation between tax administration, financial information units, cadastres, central banks, regulatory entities, police, customs. And I guess that FCInet could also be a good system to promote international and domestic wide use of information and the adoption of related legal and administrative framework. Another important fact to consider is that according to the OECD statistics, 40% of the Latin American initiative members concentrate 98% of the exchange of the request of exchange of information. FCInet can be useful also in motivating tax administration to make better use of their network of tax treaties and agreements. In this scenario, FCInet support would help Latin American and Caribbean tax administration interested in analyzing the challenges of adopting its technology and learning more about intelligence procedures and tax and crimes. SIAT can give support on it. We have a manual on tax intelligence and some related documents and training courses. The question now is, what are the challenges of tax administrations interested in adopting FCInet? In my opinion, the first one is to ensure that there is political will. That's why it is necessary to motivate high authority on the relevance of the FCInet technology. Political will enables budget, and budget is necessary. It's mandatory to implement the FCInet tool and to invest in specialized personnel. We need personnel. We need to understand the business, intelligence, risk assessment. Some LAC countries will have to comply with the International Tax Transparency and Exchange of Information Standard. Don't forget that there are still countries in Latin American and Caribbean region that are not part of the Global Forum. In most Latin American and Caribbean countries, it will be necessary to build capacities in the intelligence and criminal investigation field. It is mandatory to take advantage of the benefits offered by the FCInet network. In some countries, a greater understanding of how to use exchange of information or requests effectively will be necessary. And it is advisable to learn more about data governance techniques to ensure data quality and confidentiality. We have a recent report on data governance available in our website. It is data governance for tax administrations. Another challenge is to check the country acquisition policies to acquire the related commercial database. Not all Latin American countries, just a few Latin American and Caribbean countries have a commercial database. And that's, I guess that it is necessary. And from the FCInet side, there are challenges. I guess that it is important to define and implement a strategy to systematically disseminate FCInet with the aim of making the tax administration aware of the benefit of the system and to generate interest among Latin American and Caribbean countries' tax administrations. Regional partners like FCInet can play a key role on it. It is important to give support to interested countries. Regional partners can also play a key role on it. And regarding the FCInet cost, in my opinion, one of the biggest barriers that countries have, I understand that it may be lower if the FCInet network grow. However, reducing as much as possible the implementation and maintenance costs, or to have the support of donors or cooperation agencies to implement the system will facilitate access to low-resource countries. Thank you very much for your attention.
Thank you so much, Gonzalo. I think that you have addressed one topic that is very important, and is political will. And political will also linked to budget and also linked to the tax administrations wanted to introduce the FCInet technology. What we also see not only in Latin America or in the Caribbean, we see in all countries. So this is also an important item. The data governance, which you just mentioned, is also very important. And then the technology also to comply with that. So thank you so much for these reflections. And now we go to the second part of this presentation. We have 3 parts, and this is the second part, and it's about the OECD. So we are privileged to have 3 people from representatives of the OECD. We do have Paul Hondius, the head of unit of the harmful tax practices. We have Philip Kerfs, head of international cooperation and tax administration unit of the OECD, and we have Karine Cocker, tax policy advisor of the Global Transparency Forum. So we are looking from the perspective of tax administrations, from the perspective of the Global Transparency Forum, and we are looking for the perspective of harmful tax practices and exchange of information. So we are very happy to have not only the views from Gonzalo, but also from the OECD, and then after we will have a third part where we will also address some of our main findings in respect of the countries. But I will give the word. I don't know who would like to speak up first.
Hello, Irma. I think I'm the lucky one. This is Paul speaking.
Good. So please go ahead, and the floor is yours.
Thank you very much, Irma. And indeed, first of all, thank you for organizing this conference and for inviting Karine, Philip, and myself to contribute to this conference. Certainly a very interesting issue. Also from our perspective in the OECD Secretariat, and of course working with our delegates. I just in terms of the way we intend to proceed, Philip is with us and certainly listening in with great interest, but Karine and I will share the time that we have for our presentations. So I will comment more on the work that we do in our Working Party 10, which is a terribly technical name for the group of delegates that meet at the OECD to discuss exchange of information policies and share a bit of perspectives from the perspective of policy making on exchange of information. And then Karine will share with you the perspectives of the Global Forum that is of course responsible for implementing and reviewing the exchange of information policies that we develop, and she will share perspectives, of course, in particular on foreseeable relevance and related matters on that. But first things first, in the next 10 minutes or so, I would like to share some reflections with you on the concept of foreseeable relevance and how that has developed over time and how we have seen discussions around the concept, and of course also link that to the use of technology to do exchange of information, to cooperate between governments, and of course also with very much the ma3tch technology and the FCInet technology in mind that we have heard about earlier today in the conference. So maybe first some reflections on foreseeable relevance. I think it's sometimes useful to briefly go back in history, something we may all not remember anymore. I certainly don't, because I was too young when this whole journey started. But I think it is also mentioned in the report that initially, when exchange of information between tax authorities was developed, the premise of cooperation was that the information had to be necessary for a country to be able to ask for information from another government. And that was, of course, a relatively high test to meet. If a government needs to show to another government that it needs the information in order to be able to pursue affairs. And as was mentioned in the report, that then got changed for the now ominous concept of foreseeable relevance. I think sometimes, we use these terms in a very day-to-day manner and then don't necessarily look at their meaning anymore. But I think it is useful to contrast the concept of necessity with the concept of foreseeable relevance. And I think there are two important aspects in it. So it is, I think, obviously weaker than necessity, but it is also weaker than demonstrating relevance. I think if somebody would need to demonstrate relevance, then of course you need to provide elements that the information is going to be relevant to the receiving tax authority. But that's not the test we apply. We apply the test that it needs to be foreseeably relevant, in the sense that there needs to be a realistic expectation that this information could be useful to the tax administration that is asking for that information. And I think the commentary then provides, the commentary on Article 26 provides additional context to that in a certain way by saying it should foster exchange of information to the widest possible extent. And I think maybe a couple of reflections of what would that concretely mean. And I think Gonzalo has already referred to some of these developments earlier on. I think initially this concept was, of course, a concept of exchange of information on request, and there was a dynamic of how can we foster wider exchange of information on request, and that then indeed led to the changes to the Article 6 commentary to admit group requests when there is a group that is sufficiently identifiable as posing tax compliance risks. But it, of course, also in the meantime has led to a number of automatic exchange of information policies, including the Common Reporting Standard, and then more recently the Crypto Asset Reporting Framework, and automatic exchanges on income earned through digital platforms. And I think they all share in common the aspiration to define characteristics within a certain group of taxpayers or a certain group of assets or behaviors that make that information in a more structural manner foreseeably relevant for a potential receiving tax administration. Now, the question then, of course, that comes to mind is, what are the reasons for not having a rule that would say you could share absolutely everything? Why is there this concept of foreseeable relevance to limit certain exchanges? And I think there it's useful to maybe have a perspective from two angles. Firstly, the perspective of the taxpayer, and secondly, the perspective of the participating governments in an exchange of information. I think if one sees this from the perspective of the taxpayer, I think the foreseeable relevance principle, in essence, is really a principle that you could transpire through many areas of administrative law. It's a question of how is the relationship between a citizen and a government structured. So under what preconditions can a government gather information on a citizen on what premise can an administration ask questions or ask for documents to be produced in the framework of an administrative procedure. And all domestic laws typically have these kind of concepts of that there needs to be an interest, a case to be made why an administration has to collect certain data. And I think the concept of foreseeable relevance is really a reflection of that in terms of the relationship between the taxpayer and the government, to make sure that whenever information is collected, that this information has a expected incidence and expected relevance for the government that is asking for the information. And this is, of course, also without now wanting to draw the debate too broadly, very closely linked to questions such as the right to a fair process and also the right of privacy ultimately, in terms of how governments and citizens communicate with each other. So I think that's one dimension. Then there is another dimension, and I think that's the question of the government-to-government relationships. This concept of foreseeable relevance, of course, also tries to make sure that when one country asks another country to do a certain amount of work in terms of gathering and then exchanging information, that information is of a foreseeable relevance for the government that is going to receive that information. And there are, of course, considerations such as, have I, before I ask the question, tried to get this information through my normal domestic means, play a role, or also questions of what is the burden, what is the effort that the jurisdiction that needs to get the information and then exchange the information needs to go to before it can do so. And those, you will know that, no doubt, those are, of course, also principles that are set down in Article 26 and in the Multilateral Convention, that there are indeed tests of, are these undue burdens, or has a government tried to domestically procure the information. And these are broad concepts that I think you need to fill with life. And I think it's fair to say that over the years, the life of these concepts has changed. As we've heard a number of minutes ago, for instance, the introduction of the notion of a group request already shows that there is a stronger expectation that jurisdictions do efforts to cooperate and to exchange information. And I think similarly, the practice of automatic exchange of information takes away some of these considerations in terms of what are the burdens that another tax administration needs to go to? How can we foster broader exchange of information? And I think this is a nice bridge to transfer this into the space of the technology, because I think if you talk about questions, what can I ask from another country? What is a reasonable step to do? How can I demonstrate that it's foreseeably relevant? Of course, technology can take that to a next level. And I think we have seen that, for instance, already in the implementation of the Common Reporting Standard, where we not only developed the written rules on paper, but we also developed what is now known as the Common Transmission System. So basically a pipeline through which tax authorities can exchange the information. And that takes, of course, away a significant amount of the burden of the question, how do I get a piece of information from one government to another? I think the previous practices were practices of USB sticks and floppies and paper mails. And of course, if you have a pipeline, a piece of technology that makes that much easier, that also lowers the burden on tax administrations to cooperate. And I think in a broader reflection, and also acknowledging that tax administrations are digitalizing very rapidly, I think the question of foreseeable relevance merits further reflection on its practical application in terms of how this applies when there are more efficient technologies to cooperate between tax administration. I think the FCInet ma3tch example is one example of how information can be exchanged in a much more automated and technology-driven manner. Which of course then reduces the work that both the sending and the receiving tax administrations need to do. And in a certain way, it doesn't, of course, take away the question of why am I asking the question, or why should I need the information? I think that's a question that an administration always needs to ask when it wishes to receive information to fulfill its tasks. But of course, it makes the process to then actually ask and get that information much more quickly. So all this to say that and maybe in conclusion, to not exceed my time, that I think this is a domain that certainly merits a lot of focus. It's also work that we are taking up at level of the OECD working parties to see how technology can help improving cooperation between tax administrations and identify, I think, very importantly, concrete use cases where this technology can mean major progress. So what is the information that tax administrations most need? What is information that is conducive to be put in an electronic format where automation and cooperation through technology is sensible and can lead to meaningful improvements? And that's certainly a focus of our work very much at the moment. And we think that based on the reflections that I've shared with you in the last 10 minutes or so, that the foreseeable relevance standard allows a lot and can benefit from technology, and that it is a very permissive principle to allow wide exchange of information. But before I get into these practicalities of how that applies, I should stop because Karine knows much more about that. So I'll hand over to her, and of course, very happy to answer any questions, or also please feel free to provide comments or criticisms if you have them as part of the discussion after the presentations. So once again, thank you very much for the invitation, and I guess over to Irma briefly.
Thank you, Paul. I have just received a message from Irma saying that I can go directly after you and that we can take, I think, the question right after my intervention. So thank you again, Paul. Thanks to Irma for having me. Good afternoon to everyone, or maybe good morning. It's really a pleasure, yes, to be here to speak about foreseeable relevance. Paul already explained a lot on the concept, but this is really an important concept for the Global Forum. Maybe before going into the assessment of this concept, I can say some words very shortly about the Global Forum. The Global Forum we are speaking about, and where Secretary for which I work, is the Global Forum on Transparency and Exchange of Information for Tax Purposes. That's why, for the sake of time, we will stick to Global Forum for the rest of the intervention. And it's mainly to mention that the main mission of the Global Forum is to ensure a worldwide effective implementation of the Standard of Exchange of Information. And for this purpose, the Global Forum rely mainly on assessment process to assess all the relevant jurisdictions against the relevant standards of exchange of information. These assessments are carried out under two main processes. The first process, which exists since the beginning of the restructuration of the Global Forum, is the peer review process. And the second process, which is quite new because it is implemented since this year, it's the enhanced monitoring process. I just mentioned that we are speaking here about the standard of exchange of information on request, because it's under this standard that we assess the concept of foreseeable relevance. So for the standard of exchange of information on request, as I mentioned, we conduct peer reviews, and we conduct these peer reviews since 2010. All Global Forum members are assessed under this standard, under these peer reviews, and we have currently 172 jurisdictions which are members of the Global Forum. So you can see that we have a large membership, and we assessed all these jurisdictions. So the peer review process started in 2010, and because in 2010 we designed the standard. And these standards were designed based on terms of reference. I would not go through all the different elements of the standard, but I just want to mention that since 2010, the assessment of the concept of foreseeable relevance was already included in the terms of reference for these peer reviews, which means that for the Global Forum members, this concept was identified as a key concept to ensure the effectiveness of the exchange of information. once we have reviewed almost all our jurisdictions from 2010 to 2016, we have the Global Forum renewed its terms of reference for the standard of exchange of information on request. And under this renewed enhanced terms of reference, the assessment of the concept of foreseeable relevance was also enlarged. So it means that since 2016, the peer reviews have continued to assess the concept of foreseeable relevance, but we went a bit further in the assessment of this concept. Until 2016, the assessment mainly focused on the interpretation of the concept by the requested jurisdiction, which means the jurisdiction which receives the request for information. From 2016, we continue this assessment of the interpretation. We embark what Paul and Gonzalo already mentioned, the request on group of taxpayer, which means request on group of non-identified taxpayers. But we also embark the assessment of the concept of foreseeable relevance from the perspective of the requesting jurisdiction, which means that we assess the quality of the request sent by the jurisdiction to verify whether they implement properly the concept of foreseeable relevance when they send the request to their partners. So this is for the scope of the peer reviews. As I mentioned, since this year, we have started to implement a new process, what we call the enhanced monitoring process. What's the purpose of this enhanced monitoring process? It mainly consists of following the actions taken by the jurisdiction that have already been assessed under the peer reviews, the action taken by them to address the recommendations that we have issued in the peer review report. And the objective is to analyze these actions taken to verify whether or not the actions taken fully close the gaps identified initially in the peer reviews. So if you are concerned a bit about the extent of this enhanced monitoring process, because you may think that if we have not identified any issue in respect of foreseeable relevance in the peer review, then the enhanced monitoring process focuses only on the recommendation and will never assess again the foreseeable relevance. I can reassure you, because the other objective of the enhanced monitoring process is not only to see the action taken to address the identified recommendation, it's also to verify if, in practice, the exchange of information and requests properly work, and also to identify at an early stage any potential issue or backsliding. By backsliding, we mean that if a jurisdiction so far, provide an effective exchange of information and requests, but suddenly the cooperation deteriorated a bit with a partner or several partners, the enhanced monitoring process is the process under which we can identify this type of backsliding or any issue. But to identify this type of issues, practical issues, we are a bit blind actually, because the Global Forum Secretariat and all the Global Forum jurisdictions are not necessarily part of all exchange with all Global Forum members. And that's why the enhanced monitoring process relies a lot on the peer input sent and received from all Global Forum members. The peer input, which is basically the comment of all our members on their own experience of exchange of information on requests with their partners. This peer input enables mainly the Secretariat and at the end all Global Forum members to be aware of any difficulties in practice, including on the interpretation of foreseeable relevance. And we receive, for this first year of the enhanced monitoring process, we receive a bit more than 800 peer input. And I would not say that we have a lot concerning foreseeable relevance, interpretation and implementation, but we receive quite a number on this aspect. So these are the two processes under which we assess the concept of foreseeable relevance. Then I would move to what are the lessons that we learned from the peer reviews conducted so far, and also from this first year of implementation of the enhanced monitoring process. So the main lesson from the review exercise is that the concept of foreseeable relevance is not an exact science. If it was, the assessment would be easier. And also, if it was an exact science, I mean, difference of interpretation would occur maybe less often. It would maybe more easily for jurisdiction to agree exactly on what to put under behind this concept of foreseeable relevance. And this is why the issues of foreseeable relevance usually emerge from a peer input. I mean, that's why we are aware of this type of practical issue from a peer input. It's because this peer input will usually flag a difference of interpretation of understanding of this concept. And the second main lesson, because the standard of foreseeable relevance is not like something really, it's not an exact science, is that the foreseeable relevance is actually a matter which depends a lot on the circumstances of each request, and it must be assessed on a case-by-case basis. That's really what the peer reviews and the enhanced monitoring process provided as a lesson. And since this concept must be appreciated on a case-by-case basis, the assessment of this implementation of this concept by an assessment team or by the Secretariat of the Global Forum is not necessarily easy, and to be able to appreciate whether the implementation of this concept on a case-by-case basis, the assessment team usually would need practical example, and that's why we usually rely and ask the jurisdictions to provide anonymized copy of the request for information, but also of all the subsequent correspondence in relation to this request between the two jurisdictions concerned. And we will see a bit later, the analysis of the subsequent correspondence is really key because another lesson we will see of the peer reviews is that we have some principle in terms of the process on how to assess, how to appreciate the foreseeable relevance. And this process is really key in the compliance with the concept of foreseeable relevance. So I will now move to some example of aspect of where the position principle in relation to foreseeable relevance where we might did in the peer reviews, and the type of issues that we found in this peer reviews exercise. You will see that at the end, the Global Forum members, which at the end are the members who adopt the peer reviews and the enhanced monitoring reports, the Global Forum members remind constantly its position that the exchange of information must be provided to the widest possible extent, which is a principle given by the source of the standard. So what's the more specific lessons learned by the peer reviews, and what type of principle we have reminded in the reports? First, as I just mentioned, it's really critical to follow the agreed process, which is described in the source of the standard, one of the source of the standard, which is the commentary of Article 26 of the Model Tax Convention. So this process, this agreed process, it requires from the requested jurisdiction, the one which receives the request for information, it requires from this requested jurisdiction if it has a doubt on the foreseeable relevance of the request received to request clarification to the requesting jurisdiction, which means that in some situation that we have assessed in our peer reviews were clearly found not in line with the standard. First situation, the requested jurisdictions declined the request for lack of foreseeable relevance without seeking clarification with the requesting jurisdiction. This is clearly not in line with the standard. If the requested jurisdiction receives a request that it considered as not possibly relevant, it should request for more clarification to the requesting jurisdiction. Another situation where which would not be in line with the standard is when, as a requested jurisdiction, you delay a lot the request for clarification. Because what we want at the end is an effective exchange of information. And one aspect of this effectiveness is the timeliness of the exchange of information, a timeliness of for when the information will be at the end provided to the requesting jurisdiction. So if you delay the request for clarification as a requested jurisdiction, obviously you delay at the end the exchange of information. And this is not fully in relation to the appreciation of the concept of foreseeable relevance. But it still means that you add doubts on the request, that you hesitated a lot on the foreseeable relevance. And because you hesitated a lot, at the end, you sent a request for clarification to clarify the relevance, but months later, the receipt of the request. On the other hand, if you are on the other side, if you are the requesting jurisdictions, you have to also provide a prompt answer to the request for clarification. Again, this is for you to receive the information at the earliest possible. I will give quickly an example that we add in the context of this first year of enhanced monitoring process. We receive a peer input from a jurisdiction saying, "Oh, I received quite a significant number of requests from a jurisdiction, and these requests usually are not foreseeably relevant. I systematically have to send requests for clarification to the requesting jurisdiction, and the answers are quite delayed and doesn't help to clearly ascertain that the request is foreseeable relevance." When we analyze this peer input, we obviously, as I mentioned, request the anonymized copy of the request. And when we analyzed, we find that there was no big issue in terms of the foreseeable relevance of the request sent by the requesting jurisdiction. However, the requested jurisdiction is allowed to request any clarification it needs to process the request, to ascertain the foreseeable relevance on this side. But that's where the exchange of information were not effective. It's because the requesting jurisdiction, because it was sure that its requests were fully really foreseeable relevant, it basically did not put a lot of efforts to provide a prompt answer to this request for clarification. That's why at the end, we may not, because the enhanced monitoring report have not been fully adopted, but most likely there will not be a recommendation on the interpretation and implementation of the concept of foreseeable relevance by the requesting jurisdiction, not even by the requested jurisdiction, because it is allowed to send requests for clarification. It follows the right process. But there will be most likely a recommendation for the requesting jurisdiction for not providing prompt answer to the request for clarification. I will move a bit more clearly to a second aspect covered by the peer reviews. Still in relation with the process, the reviews were the opportunity to remind that the assessment of the foreseeable relevance occurred at the time of the receipt of the request. This means that the competent authority of the requested jurisdictions appreciates the foreseeable relevance when it assesses the validity of the request, when it assesses all the different aspects which enable it to say, okay, this request that I received comply with my international instrument, and I can treat this request and obtain the information to exchange with my partner. So what was found not in line with the standard, particularly in respect to this principle, is when the requested jurisdiction reassess the foreseeable relevance once it has gathered the information from other information holders, for instance, from a bank or any, for instance, a big company on their territory. So, for instance, based on the information gathered, we found some jurisdictions that redacted the information provided by the information holder. They redacted the information that they consider as not relevant for the investigation of the requesting jurisdiction. This is not considered as compliant with our standard, because it's on the requesting jurisdiction to decide what is forcibly relevant or not at the end for its investigation. And because the forcible relevance of the request is appreciated at the time of the request, it's not on the requested jurisdiction to decide once it's obtained the information whether what is really forcibly relevant or not for the requesting jurisdiction. So redacting the information is not per se a good practice in respect of the appreciation of the forcible relevance. Another example, a bit similar, is when a jurisdiction decided not to exchange the information once gathered, once it appeared that the person for which it obtained the information were not tax resident of the other jurisdiction. This applied, yes, in the case where the requesting jurisdiction requested information on beneficial owners of a company in the requested jurisdiction. The requested jurisdiction considered that it was forcibly relevant to obtain this information. It finally obtained on its territories the list of beneficial owners of the company, but when it looked at the list of the beneficial owners, it didn't find the taxpayer covered by the investigation, subject to the investigation in the requesting jurisdiction. So it decided not to exchange this list of beneficial owners. Obviously, this is not compliant with this principle that the forcible relevance is assessed at the time of the receipt of the request. And obviously, if you face a refusal from an information holder to provide this information, maybe based on the fact that the information holder does not consider this information as forcibly relevant, then you cannot change your position. Basically, you have to defend the request from the requesting jurisdiction and because you were convinced at the beginning of the forcible relevance of this request. So beyond this aspect of the process on how to appreciate the forcible relevance, there were some situations, I have to admit that it's not very frequent, where the lack of demonstration of a link between a taxpayer under the investigation and the requested jurisdiction trigger a recommendation. And this is, I described a bit that since 2016, we consider the quality of request. This is when we assess the quality of the request that we find that in the case of one jurisdiction, actually, this jurisdiction sends the same request on the same taxpayer to all its partners, and without, and even the requesting the jurisdiction acknowledged in its request that it didn't have any evidence of a link between its investigation and the jurisdiction with which from which it was requesting the information. And finally, one aspect regarding the quality of the request sent by the jurisdiction is the need for the demonstration of the tax purpose of the information requested. That's something that we saw a lot in the peer input. Usually, it doesn't trigger a recommendation because it's, in most cases, bilaterally resolved. Because it's not, in most cases, it's not because the jurisdiction didn't have a tax purpose to request the information that the peer input was given. It was mainly because the tax purpose was not sufficiently demonstrated in the initial request. And again, it will lead me to my conclusion for this presentation. It's that at the end, what we noted in terms of issues in our peer reviews and in the enhanced monitoring process is not really an issue about the substance on the demonstration of the forcible relevance in the request, but it's really like the need for a strong communication between the requesting and the requesting jurisdiction to ascertain this forcible relevance due to the circumstances of the cases and about really why the information requested are appropriate and forcibly relevant for the tax purposes for your investigation that you are conducting in your territory. So that's with this need for stronger communication between the jurisdictions that I close now my intervention. I will give you back the floor, Irma, and thank you again.
Thank you so much, Karine and Paul. Just to be clear, Philip was also there. He's in the room. It was just that Paul and Philip agreed that Paul will give the presentation, so Philip Kerfs is also there. We have some questions, and we want to pause just 1 second to reflect on this. And the reason is, and then after we will have the presentation by Tofik regarding the country perspectives, that what we did in the report, but we want to pause a little on this. And the reason is because I think that we can write thousands of pages on this, and we will still may not be able to grasp all the dimensions and how we deal with foreseeable relevance. And as I understand also from the presentation, thank you, Karin, for telling us about the enhanced monitoring report process. There is a question actually if there is some terms of reference on that enhanced monitoring reference process. But one question that we could have, and there are, I will give to also some in a second the word to Esther, who is also the main, as I say, the main author in this report on the part of tax. And we struggle a lot trying to find, based on the questions asked by FCInet, to take a stand on where is foreseeable relevance, how we use the technology. We needed to understand the technology. We will not be to the level of Jules, never, never, never. We tried to understand the technology. We went back again for questions. But at the end of the day, it is up to what we need to do next. So where is going to be the policymakers, where are going to be the international organizations, where are going to be the countries, tax administrations, what can we do next? And for that purpose, I have 2 thoughts, and I will want to share those before I try to, I give the word to Esther, who will go more in detail. And one of the things that we see is that we are not in, we started with the change of information on request. Now we have spontaneous, now we have automatic, and we see that the multilateral convention on administrative assistance has been kind of the instrument where countries say, well, we can have a competent authority agreement, we can agree on that. For instance, one example is the country-by-country reporting, multilateral competent authority agreement, where countries are still able to exchange information without having to negotiate Article 26 of the tax treaty concluded by them. So this is a multilateral movement. And then I thought, well, should we not, in terms of using the technology of FCInet and to make it more safe for the tax administrations, to perhaps think about this competent authority agreement? But if that's the case, then how will be this developed? Can we still use what is nice about the multilateral competent authority agreement is that countries can use it and competent authorities, and you can agree 2 or 3 or 4, or if you have many, but you can still use it based on the MAC, the Multilateral Convention on Administrative Assistance. So can we develop a multilateral instrument? What will be needed? That is also a part that we think of for recommendations. But I think that since we have here Paul and Karin, and we are developing this process, we need to ask also this question. And the second question we have is that we saw at the beginning, and I'm very happy to hear about the enhancing monitoring process and review of foreseeable relevance, because it has changed a lot. But still there are issues of technology, because this, when Karina was presenting, was on a change of information on request. But when we talk about spontaneous, we talk about automatic, there is still this level of checking. Let me check. And we as lawyers, I think that we always think about that. So the question is, do you have any thoughts on how we also not apply it only to on request, but also to spontaneous, for instance, what is the case in the FCInet technology? And then the final reflection that I may have, I mean, we may have time, you may take this with you, but I thought I just want to ask it. For Paul and for Philip, we see that there is a lot of interest now, and especially within the working party intent, but also in the Forum of Tax Administrations to use technology. So if we have this technology, how we can make sure that the governments, because one of the problems you have with the governments is that, like, when everything happens, we need money. we don't have the money, we need the budget. So how we make sure that the governments will have the budget, because it's at the end of the day, it's just looking at the efficiency and the benefits. So those are 3 questions I put you on the spot, but I will give also time also, if Gonzalo wants to also comment on that, please be welcome. But I give you some time to think about it, because also Esther has a question. So let's, Esther, please go ahead, come here.
Thanks again, Irma. I only have one question. And this question is for Gonzalo, Paul, and Karin. And I do not expect an answer to this question. It is a question that is bothering me. And it is, as soon as I was introduced in the technology of ma3tch by Jules and the team from FCInet, I felt I was enthusiastic on how it works and the potential that it would give in international information exchange. And we all can see that it is privacy preserving and that it is not only reactive, since relevance is the assessment criterion, but it can also be used as a proactive tool because it is able to detect trends in, specific issues on tax fraud or other financial crimes. And why is it, and that's the question that is bothering me, why is it that tax authorities are still hesitant to use it? Is that only because they don't understand the technology? Is that the aim that we should have to explain how it works? Or do you think that other issues are in play for tax authorities to actually use the tool? And again, I do not expect an answer. Your reflections will be more than enough.
Thank you so much. And then we have a final question regarding also from the chat, and it's my former PhD, now postdoctoral researcher at the ICTD, Frederick Müller. So Frederick, you are still with us. So thank you for the interesting presentation. Will you say that in aggregate, the concept of foreseeable relevance poses a lot of disputes? How frequent are the cases that you described where requests are rejected or that clarifications are requested? The question is in the chat. So we have these questions. I don't know if there is any other question in the audience. No? So well, let's go ahead. I don't know even who wants to start.
I can give it a go unless Gonzalo
Yes,
wants to
please.
go, because it is, yes, no, thank you. I think those are excellent questions. And I think for me, I mean, I will of course not comment on the questions related to the peer review process. I think those ones are for Karin, but on the ones maybe more linked to the use of the technology of the ma3tch technology. I mean, I think in my mind, I see a lot of parallels, although it's of course not a perfect parallel with the work that we did a number of years ago that I briefly mentioned on the common transmission system, which helps information, and particularly automatically exchanged information, but also increasingly spontaneous and exchange on request information to travel from one tax administration to another. And I think the FCInet ma3tch technology is similar in that regard, as that it is a particular process for initiating exchange of information between tax authorities that works on the premise in the beginning to see whether somebody that is falling into a relevant group as a taxpayer in terms of behaviors, in terms of assets, or in terms of other features, has a link with another jurisdiction. And I think that's also for me where very much the crux of this is to also in response to Esther's question, how can this be brought forward? I think it all depends on, I think, 2 very practical questions. I think the one question is, what are the use cases that we can identify for which this technology can be potentially highly beneficial? And one could certainly do a creative process in terms of asset types or income types or types of taxpayers where compliance concerns in a more structural manner are still present, and where such a technology could be beneficial to retrieve information that other governments have available potentially. And then I think on the other side of the equation, maybe already took that a bit away now, I think there's also the question, what is the kind of information on the side of the government that would then provide the information, so that would do the match, so to speak, how this information is available and searchable in a database that allows this process to run. So I think it's a bit those two aspects, and I think that's really a matter of policy priorities and tax administration capacities that need to come together so that this can then become, so to speak, really what technology fundamentally is, the piece that brings two people together, which I think this is fundamentally what the system does. It's high priority cases that need further compliance work on the one hand, available data in databases on the other hand, and then bringing that together. And I think you're absolutely right, maybe in conclusion, Irma, that once you have identified those aspects and you know what the scope can be, that then indeed a multilateral competent authority agreement to formalize this working in terms of what are we asking, what do we get in return, what are the timelines, what are the financial arrangements, is something that could work very well. And I think personally, if you do these steps, that then also you will find a way to be fully in line with the foreseeable relevance requirements. I don't think that they would be a major hiccup when these two things get brought together.
Thank you so much, Paul. I will give the word to Karine and perhaps Gonzalo for some final reflections. But first, Karine, would you like to respond to? We don't hear you.
Yes, no, I think it's okay. Thank you, Irma. I have nothing really to add on what Paul just said. I fully agree. Maybe on the one very pragmatical aspect, as someone who worked in the tax administration and who had to try to convince the policymaker to implement some new tools or maybe some new mode for exchanging information. I guess one important aspect is to have a success story to tell to the policymaker. So any success example that we can have, it's obviously always something good to convince, yes, the policymakers.
Yes, completely agree. And I think that after this report, based on the tax and criminal, we really need to go, and I also told Jules and the FCInet that successful stories, cases will always help. Let me give the word to Gonzalo for some final reflections before we go to our country perspective. Yes, Gonzalo.
Thank you, Irma. In the academic ambit, there are not uncomfortable questions. So we can give an answer, but I guess, honestly, I guess that to motivate countries to implement this technology that is useful, we don't have doubt that it is very useful for tax administrations. But we need to prepare the land. Especially in Latin American and Caribbean countries, there are different countries. You find countries like Mexico or Brazil, they have strong tax administrations, or Chile. But in other cases, there is not a tax intelligence unit or risk assessment unit, or you don't have people with expertise to manage software like this. So if we have the car, but we don't have the driver, we will be in problems. And I guess that first it's necessary to communicate what FCInet is to make it understandable for tax administrations, and then to prepare the land, legal framework, administrative framework, people we need, internal structure to use it. Because in my opinion, one of the biggest mistakes we can commit with FCInet is to implement FCInet in a country without capacity, and then to say or to conclude that it doesn't work. It works, but you need everything, not just the system. And I guess that the colleagues from the OECD, if there is a big group of countries interested in the FCInet system, could think in work, in competent authority agreements, in the framework of the multilateral convention to implement it, because we need specific rules. And it is impossible to do it bilaterally it is possible, but is time consuming, it's costly. Regarding the Frederick question, we don't have statistics about the problems that countries are having at the moment to interpret the forcible relevance principle. And when there are problems, we don't know who is right or wrong, which part is right or wrong. But I told this because it surprised me in the activity we had in Guatemala just on forcible relevance that a lot of countries told their histories, and they say, I sent exchange of a request of information to other country. I put all the necessary information about the audit, the risk, and the receptors told me that they consider that there is not risk and it's not forcible relevance. But I guess that what is necessary is to have a common understanding on the principle. I know that the OECD made a big effort. There are a lot of guidance, events, training, but we can imagine all cases. And there are hundreds, thousands of different cases in which countries or also taxpayers can have different point of view on the existence of a forcible relevance. That's why we, as I told you, it's a social construct. We need to follow up what is happening and to evaluate different cases and to evaluate when to flexibilize the principle.
Thank you so much. So I think that these questions, and you know, this is recorded, so we will have it also available for everyone. And it's also the purpose of this to continue the discussion. So we just started with this. Also from academic perspective, policy perspective, tax administration perspective. Then I will just give the word to Tofik Hassin, who also is part of the team. And one of the things that we thought was interesting was about not only presenting the criminal law, the tax law perspective, but also looking at some countries, how countries have discussed it on the foreseeable relevance. It will not get to the level of the peer review reports. It will not get to the level of the in-depth knowledge of the OECD on this, but it was kind of nice to see what we can do with the countries. And we also, and Tofik developed also together with Esther, a questionnaire. I have to say I'm only the middle here because I have worked a lot on exchange of information and taxpayers' rights since 2009. But this is really Esther and Tofik and Janamik, so I'm just kind of the vehicle here. But one of the things we need to talk about countries. And this is a very short overview on the topic that perhaps will help. But I'm looking forward to Paul, to Karin, to Philip, to Kilan, who I also see from the OECD, tax crime, and to Gonzalo, to continue this discussion also in an international policy making level. So please, Tofik, I will share your slides so you can also give your presentation here. Thank you.
Yes, thank you very much, Irma. As Irma said, I won't make it too long. Let's see. Yes, definitely. So I'm Tofi Nisi. I conducted country research. For the research, we looked at 11 countries and looked at specifically the concept of foreseeable relevance and what does it mean, how is it formalized, but also how is it operationalized. How long do I have, by the way? Perfect. Yes, first, I also want to thank Gonzalo from the CIAT, Paul, Karin, and Philip from the OECD for being present and sharing their thoughts. Because information exchange has cooperation at its very core. So we must raise the awareness at the level, not only regional, but also international. And these organizations on the regional and international level can offer the help to individual states and to build the capacity in the regions. In the context of this research, we took a trip around the world. As you can see, 11 points here. We looked at France, Germany, Spain, and Italy for Europe. And we looked at Canada, Mexico, and USA, Colombia for the Americas. In Africa, we looked at Nigeria and South Africa. And in East Asia, we looked at Indonesia. As we all know, one of the best places to explore the world is a library. So that would be online or physically. But after having conducted this research, I think it would have probably been easier to visit each separate country and knock on the door, because the differences between countries are noticeable in accessibility, availability, and codification of the formal and operational use of the foreseeable relevance criterion. After we have conducted the research, we gained several valuable insights in relation to the time, and to leave room maybe for more questions after this, I will focus on a few of those, and I refer to our paper for any additional information. So first, please keep in mind that the countries use different instruments for the exchange of information. For example, the DOC within Europe, so the Directive on Administrative Cooperation, the OECD model TIEA, that is the Tax Information Exchange Agreement, and the OECD Model Convention, specifically Article 26. This already creates differences in the treatment of exchanging information and the concept of foreseeable relevance, depending on the instrument. Following this, there are differences in the domestic interpretation and operationalization of the standard. And this could, of course, create barriers where you don't have a standardized system such as FCInet to digitally place borders where they are needed. So one of the key takeaways that we had was the way in which competent authorities in jurisdictions assess whether the principle has been met, has emerged several insights. So we see that that legislation tends to place a greater emphasis on the exchange of information on request rather than spontaneous. We even see in the TIEA, model TIEA by the OECD, that Article 5 does not include spontaneous exchange. And in the commentaries, it is said that countries can include it on a bilateral level. Countries with more developed frameworks, they demonstrate a higher frequency of information exchange. And globally, most countries adopt the OECD standard for the principle of foreseeable relevance. It's very interesting to see that countries with higher capacity and more developed frameworks also exchange more, because it could be feeling safer for them, or because they have more knowledge on the topic and are more familiar with it. So I'm going to discuss a few cross-border challenges that we identified and a few cross-border solutions for them. We see differences in the thresholds for foreseeable relevance, as Esther also mentioned before. And for this, there needs to be a clarification and harmonization of the definitions, not only on a national level, but definitely also on an international level. To harmonize these definitions, you need to look at the specific countries and why countries differ in their definitions of foreseeable relevance. The competent authority has proven to be very important to have clarity on whether which competent authority can exchange information and for what purpose. For example, in Italy, there are two competent authorities. And please forgive me for my perfect Italian, but Agenzia delle Entrate and Guardia di Finanza. One of them looks more like a traditional tax administration, and the other is a financial police department. When you exchange information for the purpose of taxation or for criminal purposes can differ, and different countries also include different kind of thresholds to exchange this information. So therefore, we also need to define clear roles and responsibilities. We also notice that countries have reciprocity limitations. They want to exchange information with countries that also exchange information with them. And sometimes it can be more difficult for a country with a developed, for an underdeveloped framework to exchange information than a country with a more developed exchange of information network. Therefore, we need to map and align reciprocity requirements between countries. And one of the biggest cross-border challenges that we noticed was divergent privacy and secrecy standards. This was actually very interesting because we see that within the EU, we have the GDPR. So countries have a fairly similar framework for privacy. So they know how the information is going to be treated approximately. But outside of Europe, this can be challenging. You don't always know or have access to the information or the specific privacy framework. And another aspect is that most privacy frameworks actually are still upcoming in the world. So it's also very important to, on a regional and international level, start mapping these privacy and secrecy frameworks in relation to taxation. The last one that I want to highlight was the limited transparency and inconsistent local rules. On a local level, we also see that different countries interpret foreseeable relevance differently, especially on the level of spontaneous exchange. When they exchange the information on the level of bilateral treaty or multilateral treaty, this does not really cause large problems, let's say, but when a country spontaneously does it based on its national law, this can also cause difficulties. And for this, we need to enhance procedural transparency and the technical capacity of these countries. And for this, FCInet actually not only facilitates the building of the necessary capacity and knowledge, but could also accelerate this process. It could systemize this in a certain way. So these were the insights from the comparative analysis that I wanted to share with you now. I refer to, again, the paper for any in-depth knowledge on this. And again, I want to stress that on the level of regional and international organizations, the clarification of these definitions could very much help the international framework going forward. And also looking at the questions that we have set up in the questionnaire actually maps these problems and offers stepping stones to build this framework. Thank you very much.
Thank you so much, Tofik. I think that we have provided just a small, very tiny little part of also the part that is in the chapter of the report and is in the comparative analysis. There are some questions and there are some challenges, but I think that it is important to be aware of the challenges. And one of the things that I want to do, and we are going to also hand out the report because we have the report online. We have shared it with the audience online, but we also have the report in print. So we will be concluding today the meeting, the conference. But one of the things I want to highlight is what is next. And what is next means that when the University of Groningen and asked by FCInet started discussing about FCInet technology, it was about exchange of information. It's spontaneous on request. It was the result on spontaneous. And then FCInet asked us as scholars, academics at Leiden Law School to ask specific research questions. And as I mentioned, we have to dive into get knowledge of the technology, but we also needed to ask other questions. And we needed to ask other questions, and we needed to also be critical regarding what are the problems, what are the challenges, how we can solve the challenges. And you also see in the part of recommendations, I'm very happy to hear that the OECD and the Global Transparency Forum is now reviewing the foreseeable relevance with these enhanced reports, because actually that was one of our first recommendations. We need to address foreseeable relevance. Foreseeable relevance started in Article 26, 2000, when we started even before. But we are more than And since 2009, when we started with the global transparency and the standard of exchange of information, we are more than 15 years ahead. So how the technology, how the differences on foreseeable relevance. So this is also a challenge that we have. We have also discussed about the possibility to have multilateral instruments. This is also the question that we ask, but we need to do more on this. And our conclusions and our work will stop here in the sense that we as researchers, we give the report. We will present the findings of the report as much as possible to others, stakeholders. We also see people from Asia, from Latin America, from Europe, from the Caribbean, from Africa even. You have some in Sri Lanka, South Africa. We have also from the Asia. So, but the question is how we make sure that this is international, global, that the challenges would be addressed. And that is also for the policymakers. So the way forward is for the policymakers, and we are very happy that we have today some international organizations, and we will continue providing the report, but it's also our work. We'll stop here. We will keep presenting the report. We will keep presenting the work that we have done. But now is a moment to pause. So our paparazzi was just finished. So we just finished this conference. As I mentioned, this is just the beginning. Thank you so much, everyone, also to the speakers, to Gonzalo. I know it was really early for you. Some people also from Latin America, very early. For Asia, middle of the day. So we are very happy to have concluded, and we will share the slides and the recordings. Thank you so much, everyone, and have a nice afternoon, evening, rest of the day, and everything. Thank you so much.